Okay, so this is the second lecture of this paper discussion that I am doing, right, each week. I'm taking 5 to 6 questions from previous year paper, right. So last week I discussed paper number, 2019 question number 1, paper 1. Now today I will be discussing, question number 2 that consists of actually 4 questions, right, and question number 3 that consists of 3 questions, right. So total 7 questions I will try to discuss today, okay, and that is in the paper number 1 part A, okay, right, Constitution and Administrative Law. Okay, now if you look at the paper number, 2019 paper, right, 2019 paper, question number 1, 5 parts we have already discussed, right. Now today I am going to discuss question number 2. So 2 have basically 3 parts, A, B, C, D, right, A, B, C, sorry, and A have basically 2 parts, right, 1 and 2, right. So it was basically 10 marks, and then we have 15 marks, right. So each question is basically 50 marks, okay. Then we have question number 3 that we will discuss, A to C, okay. So altogether 7 questions that I will be discussing today, okay. Now if you look at question numbers 2, then the first question is basically give an overview of administrative tribunal in India with a special reference to administrative tribunal established under the Administrative Tribunal Act, right. Now this question is a very simplistic question actually, right. Actually it talks about that you give an overview of administrative tribunal in India, right. Now and then they talk about that in light of discuss the growth of administrative tribunal in light of this particular law, right, Administrative Tribunal Act. Now if you must be knowing already that article, we have tribunals, a specific part in our constitution to 323A and 323B that talks about tribunal, right. So 323A basically talks about administrative tribunal, and 323B says that okay, the government, the parliament may by law provides for tribunal in certain list, right. So they give us around 7 to 8 topics. Then in these topics the tribunal might be provided, right, a tribunal can be made. Now those who are of non-law background, right, must be confused that what is the meaning of tribunal, right. So obviously we do not have time to discuss the whole concept related to it, but normally speaking we think of it as a sort of an administrative, quasi-administrative or quasi-judicial body, right, for the purpose of solving the dispute related to a specific matter, right, a specific matter, right. So in that tribunal, that is why we have 2 type of members generally. One is the judicial member who will apply the law, and second is basically administrative technical member in that particular field for which the tribunal have been established, right. So here it is basically talking about administrative tribunal, not anything else, right. So how to approach this question, right. So firstly we will talk about the constitutional provision related to tribunal, right. So you write these constitutional provision, right, and then write the interconnection between 2 that I have just explained to you, right. And then the question is with a special reference to administrative tribunal, right. So after explaining the general overview of constitutional provision with respect to tribunal, right, you come to a specific to administrative tribunal, right. You go into detail that what is the purpose of administrative tribunal under article 323A. Now if you look at article 323A, it actually talks about that it will be for the purpose of all the government employees, right. It very nicely defines what are the categories of government employee basically it will attract to, right. Then under that article, parliament by law have passed this Administrative Tribunal Act, right. So go into the nitty-gritty of Administrative Tribunal Act, right, what is the structure of it, how many members will be there. There is a 2-layered structure, right, the union tribunal, tribunal at the central level, then we have tribunal at the state level, right, and what kind of guideline they will follow, right. They will be equivalent to high courts or they will be not equivalent to high courts, right. Their appeal will lie where, right. So that particular thing you have to write. It means you have to talk about Administrative Tribunal Act in detail, okay, and that have been passed in the pursuance of article 323A, right. And then you have to come about and write the a specific good things about administrative tribunal, right, that how it have enabled, right, government officers to seek justice, right, in an effective manner, okay, in effective manner, okay. Now then also you can write ki this popularity of this tribunal have led to establishing of multiple other administrative tribunal, tribunal which is of nature of administrative tribunal, right? Then you can cite NGT, the very newest one and the most powerful in that sense that it have a very large area of legislation that it deals with, right? Previously we used to have separate Air Act, Water Act, etc., and all of them have a separate machinery, right? Now we understood that environment cannot be separated into these three, so we came up with a one tribunal, that is your NGT. Okay, so that is that example that can be cited. Okay, so that is in the conclusion part. Okay, but in the beginning part, the constitutional provision, then going into detail about Administrative Tribunal Act, right, and then come to that how it have given us a very good platform to enable for the development of other tribunals as well. Understood that particular point, right? So the general requirement of the question is this itself, right? Give an overview of the growth of tribunal. Okay, so do not only focus on the Administrative Tribunal Act, right? Give an overview of growth, right? To cite multiple tribunals and write that the Administrative Tribunal have set up the benchmark on which other tribunal have been based. Okay, now if you want, you can mention in Sampath Kumar case that talked about judicial review power cannot be taken by the tribunals. Parliament cannot pass a law saying that the judicial review power is taken away, right? So judicial review is a part and parcel of basic structure, right? So after that, tribunal became sort of I will not say less powerful, but they cannot override the High Court power of writ. That is actually the point, right? There is a question also, we will see that. Now let us come to question number 2A1, right? So if you look at question number 2A1, it says revival of Panchayati Raj system in India is an aid to reduce the workload of the judiciary. Comment. It is a 10 marker question. Now if you look at this question, very interesting question actually, not 15 marker, not 10 marker. Revival of Panchayati Raj system will act as a revival of Panchayati Raj system will act as a aid to judiciary, right? So it means you have to talk about that part of Panchayati Raj system which actually will lessen the burden of the judiciary, right? Now I will tell you the structure. First let me answer the crux of it. The answer is basically that Panchayati Raj institutions have two provisions. One is of the Gram Panchayat, Nyaya Panchayat, and second law is there is a Gram Nyaya Act. Okay, so these two provision actually happens, or this creates organization, creates judicial structure at a lower level, right? Now when we'll see our whole judicial system, right, mostly in the high courts and in the Supreme Court, the cases are not pending for 90% cases are of less than 2-3 years, right? So most of the cases that gets lot of time delay, that is basically in the district courts, right? So basically what you have to emphasize in your answer, that some of the burden of the district court can be taken away, right? Now once this burden is taken away, there will be a sequential effect, meaning that the cases from district court will less to the high court, and from high court it will be less to the Supreme Court, right? So it will be sort of a cascading effect, right? So that point actually you have to write. Okay, that point actually you have to focus, that how it will help us. Okay, how it will help in reducing the workload of judiciary by basically lowering the input cases, right? So if the input cases at the district court is lowered, by default at the top most you will see that number of cases will get lowered down. And then we will talk about the machinery. The two machineries there, one is the concept of Gram Nyaya Act, the law which provides for Gram Nyaya in multiple panchayats, right? And then you can talk about the concept of Nyaya Panchayat, right? And the third concept actually you can talk about is basically Lok Adalat, right? So Lok Adalat is not exactly is formed under Panchayat, right? But somehow at that level it is formed. Okay. However, Lok Adalat, we have a separate National Legal Service Authority Act that provides for the establishment of Lok Adalat, that has nothing to do with Panchayati Raj institutions, right? But mostly it is formed at block level, right? So you can also sum up that, okay, these are the also institutions that we can complete. We can be can be clubbed together with Panchayati Raj system. Okay, or you can actually suggest that, okay, this Lok Adalat responsibility, formation responsibility can be given to Panchayati Raj institutions. Okay, so that that sort of stuff actually you can write. Now coming to the structuring, that how will you structure this? This is the answer actually, content of the answer overall. Now the structuring will be that you will start with, right? You will start with that how the workload of judiciary have been increasing, right? So in the first part you will talk about workload of judiciary, how it have been increasing. You can give some data, 2 crore cases pending, it have increased substantially, right? Then you will come to Panchayati Raj institution, that will help us to reduce the workload. Okay, right? Then you will cite those three institutions that I talked about, right? And then you will cite that how it will reduce the workload, right? Mechanism. So you will write that how, right? In that how will you write it? So you will simply write that, see, these institutions basically tackle the case at the point of creation, at the point of input, right? That we discussed, right? Now at the point of input, if the cases are solved, then obviously it will have a cascading effect. Understood that particular point, right? And then you can conclude with, and this will be very longer part. Why? Because you have three institutions. You will write small 2, 3, 5 lines about each of these institutions, right? And then you will finally conclude with some again examples, like you must have seen the Lok Adalats have recovered the amount of money, and which is more than actually the total amount of money recovered under IBC. Right? So you can actually cite it as a very good example, that IBC being such a corporate client, etc., but they have recovered less amount of money than the whole Lok Adalat have recovered. Okay, so that example can be cited as an example that how this revival can lead to pendency of cases. Understood that particular point. If you want, if still time permits and you still have some 150 words is not over, sorry, 250 words, then you can also add up some of the suggestions. Okay, some of the way forward you can add in the end. Okay, but remember, the question is really philosophical in nature, right? But you have to apply some of the journalistic comment as well as some of the legal aspect of it, right? So Gram Nyayalaya Act has to be studied, right? So if you have not studied it, I will suggest you go through the Gram Nyayalaya Act. Okay, so that ends our 2A. Now let us come to 2B. Now 2B, what I say is a very philosophical question actually, right? It says power of parliament to amend the constitution is wide but not unlimited, right? Very typical question. Each year there is a question on Keswanand Bharti doctrine, right? Each year. Okay, power of parliament is to amend the constitution is wide but not unlimited. Okay, now what is the limit? Basic structure, unlimited, full stop. Do you agree with the statement? Obviously there is nothing to disagree. It is the Keswanand Bharti doctrine actually. Do you agree with the statement? Discuss whether the doctrine of basic structure has reinforced the power of judicial review under the constitution, right? That is why I am talking about the Sampath Kumar case has to be mentioned, right? See, the structure of this question actually is, the structure of the answer is actually that you have to talk about basic structure doctrine, right? And you have to basically affirm, write argument which affirms this statement. Now the best way to do that I always tell you, that no matter how smart you are, right, you cannot write beautiful lines as the judge right? So what I will suggest all of you is that go through the Keswanand Bharti doctrine, Keswanand Bharti judgment, right? It's a big judgment, but still find some good paragraph from it. Okay, and remember that paragraph as it is, that you have to quote in exam if there is any question with regard to Keswanand Bharti, right? Like Justice Khanna's, right? You can quote even Justice Ray. Okay, right? Understood that particular point? Okay, so you say take some of the good lines, few paragraph from it, and if you are unable to quote it verbatim, but at least quote 70-80% things should be same. At least the keywords should be there, right? It is an organic document. The constitution is a living document, right? It carries the soul of the nation, right? It cannot be interpreted like a normal law, right? Understood, right? So it has to accumulate the social and economic changes that is going into the society. It has to adjust with themselves. Okay, so those sort of line actually you have to write the philosophical aspect of it, right? Then go to why it is not unlimited. Now you write that what is the meaning of unlimited, right? Then you say that the whole word unlimited have been limited by the word basic structure. Now here you don't need to write the plethora of case laws, it came after this, no, all this. You do not have to write from Sankri Prasad to Keswanand Bharti all case laws. That is not the demand of the question. Okay, so do not go into that. Okay, then you come to that this basic structure doctrine have been expanded through multiple judgments, as it was not clear in the major judgment, right? And then you focus mainly on judicial review, right? So the first half of your answer will basically focus on this statement, good lines from Keswanand Bharti judgment. Second, and then you write basic structure, so judicial review as a part of basic structure, second headline, right? And then you come about and write that how this judicial review have been a part of basic structure. Understood that particular point, right? In fact, Menka Gandhi also told judicial review is a part of basic structure. Sampath Kumar you can cite. You can also cite this Indira Raj Narayan Gandhi versus Union of India, not Union of India, it is a state of UP, I suppose. You look at it once. There's one candidate also in Bareilly, in Allahabad. He was the candidate against Indira Gandhi. Raj Narayan versus Indira Gandhi. Yes, that is the correct case, right? You can cite that case also. In that also it was held the judicial review is a part of basic structure, right? So 3 cases you cite, right? And you write the ratio of those cases, right? Okay, this is the smaller fact and the court held it is a part of basic structure, right? And you conclude it. That's it. I mean, that is the conclusion itself, right? So it is a very simple question. First part, you talk about this particular line. It is not unlimited. It is wide but not unlimited. Justify it with good lines. And the second part, write the heading judicial review as a part of basic structure and write the case law. That's it. Understood that particular point? Okay. In between, you can also write that how basic structure is a very generic doctrine. It have been refined further by the courts, and then you can say that okay, judicial review is a part of basic structure. Okay, understood that particular point? Okay. Now discuss whether the doctrine of basic structure had reinforced the power of judicial review. The answer is yes, supported by case law, that yes, it have reinforced the power of judicial review, right? In fact, one more thing actually here you can write is that it have given an additional ground to the court to judicially review something. Okay, it have given an additional ground to the court to judicially review something, right? Because this is one of the ground which have been created by the judgment itself. Okay, so in that sense also it gives an additional ground of judicial review. Okay, so judicial review as an inherent power of the Supreme Court and High Court is a part of basic structure that is already there, right? So the ground of judicial review are multiple, right? So mostly should not violate the fundamental right. Okay, but it should not violate the basic structure. That is also one of the new ground of judicial review, right? So that is something also you can say that see, this judgment has led to addition of this new ground as well. Okay, so that part if you want, you can mention that part also. Okay, now let us come to question number 2C. Now this question number 2C again is a very interesting question, right? It basically asks you a very typical question, always it is asked, right? Is basically you have to write the connection between Article 226 writ jurisdiction of the High Court and Article 32. See, examining the nature of the power of High Court under Article 226 of the Constitution of India and distinguish it from the power of Supreme Court under Article 32. Now this is something if you are a serious law student, you must be knowing it, right? The main question comes that how to structure the answer. That is actually the major difference. Okay, nothing else. Now you will start with the meaning of writ. You will write a generic line. Okay, both of them provide writ jurisdiction to the higher courts, right? And writ have been historically intended to as an effective method of justice delivery. Okay, you can write common law doctrines regarding it, right? Okay, writ was basically something which king used to issue. Understood, right? And it used to override the court orders. Okay, so little bit about writ, historical background, how it is a common law origin. Okay, then you come to the distinction between 32 and 226. Now what is the distinction? You must be knowing already. Can pass only for the violation of fundamental right, and it can pass for the violation of legal right as well. Okay, legal right as well, and then you can dwell upon that how it is wider against one another. Now obviously it is a one line statement that I am giving, but what you do that you verbatim quote the article, right, and then you analyze each and every word of that article, right, because the word other is written, right? So you write that the word other here signifies any legal rights. Okay, and in the case of 32 no such word is there, right? It means it signifies only fundamental right. Okay, so you write the verbatim article, at least the major points of that article, I mean major keywords of that article, and then you explain it. Okay, so 2-point explanation will be there. First, on the ground that it can be passed for fundamental right, it can be passed for both. Then you write as a consequence of the first explanation, second explanation, you write that it is wider. Okay, then you in the conclusion part and support it with the case law. Okay, the multiple plethora of case law, right? You can cite any case law where there have been multiple huge case law, right? So any one or two you can cite actually, right? Then you come to a very particular thing that will that will be your answer differentiator, that write that how this 226 have often been misused. Okay, right? It means it has not been used in the way it was intended to be used, right? The best example you can give that if the government provides a separate machinery for the purpose of suppose any commercial decision, right, like this IBC, right? What is the function of IBC? Okay, this will be a company. If they do not give money to the operational or institutional creditors, right, then the whole mechanism will kick in, and there will be a multiple step process, and ultimately that problem will be solved, right? So it is a pure commercial law. Now suppose a step, suppose there are 3 steps. Now after step 2, someone goes to a high court and takes a stay under article 226, and high court is empowered to give that stay, right? So the whole purpose of this machinery is defeated, right? Okay, right? So that particular point you can write, and then you can write that how court have read certain restriction in article 226, that high court should not be always eager to pass judgment under this, pass a writ under this article, right? But they should actually see, right, the commercial judgment, the economic judgment should not be interfered generally by the courts. Understood that particular point? Okay, so that point you have to answer in the conclusion part. Understood, right? So if you will see, if you simply explain the difference between these two, it is only the body part, right? This is the extra part that I told you have to write in conclusion. In the beginning you have to talk about writs itself. What is the function of writ, meaning of writ? Okay, so that also, and that is something you have to study actually, right? Mostly students study that 226 power is wider, it is smaller, right? And they go done away with, right? But that makes answer very generic, okay? So answer should be something, it should have some extra element, right? So that it will create a difference, okay? Now let us come to question number 3. Now question number 3 is a very interesting question, I must add. It says, while conferring the power of delegated legislation on administration, while conferring the power of delegated legislation on administration, let me write it down, delegated legislation on administration by enabling act may specify the procedural safeguard to be followed in the exercise of the power. Okay, so if an act is giving you a delegated legislation, to executive, right, then it may provide enabling procedural safeguard, right? Now what are the procedural safeguards generally is provided? There are 3 basically. You will lay the rules made under this particular law, or you will publish the rule, right, or you will consult the public before coming up with the rule, right? So generally there are 3 procedural safeguard that is provided in particular law, right? What are the consequences of non-compliance with requirement as laid down in act? Discuss with the help of decided cases. Okay, now it is an exact concept based question. Let's see, what are the procedural safeguard? So we have publication as a procedural safeguard, laying as a procedural safeguard, and consultation of the procedural safeguard, right? Now what will happen if it is not adhered to, right? So the ultimate analysis, if you will do, you will see that the law basically says that if the intention of these procedural safeguard is to be compulsory, meaning if the word shall have been used, okay, if the intention have been that it is compulsory, then non-fulfilling of these procedural safeguard will basically violate that particular delegated legislation. That delegated legislation must be expunged, right? So that is the major concept. And you have to support at least 3 case law for these 3. There is a very famous case law with regard to state of Gujarat, right, that there was a requirement that it must be published in Gujarati newspaper. Okay, it shall be published in Gujarati newspaper. The court held that it is not recommendatory, it is actually mandatory, right, because that particular legislation was actually related to some local issues, and the people who will deal with that local issues only know Gujarati. Right, so if you publish that particular rules in the English newspaper, that will have no consequence at all, right? Because the intention of the act, why it has specifically said it must be published in Gujarati newspaper, right? So then the executive was saying that it must be published in the newspaper, right? So if the newspaper it have been published, then it's all right. So it need not to be a particular language. The court held that no. Purposefully the legislature must have thought that it should be published in a Gujarati newspaper. Right, so it means the Gujarati newspaper. Understood that particular point? Okay, right? So that is actually the crux of this question. But the question is that how to go about it. Now this part, this procedural safeguard part, that will be in the body. But what about the first and the last, right? So in the introduction part, you will little bit talk about delegated legislation. Right, very normally delegated legislation has become need of the day, right? With the passing time and with the complexity of economy increasing day by day, the number of delegated legislation have been increasing. Okay, so controlling of it becomes important. Okay, only not one paragraph whole, large paragraph, 2, 3, 5 lines maximum. Okay, then we will talk about the delegated legislations should be subject to certain safeguards, right? Safeguard might be on the side of judicial safeguard, judicial control, right? Or it might be inbuilt in the law itself. Okay, so we will talk about, basically we are talking about type of safeguard that is available, right? And then you will go specifically to the inbuilt safeguard that is given in the law enabling act, right? And then you will explain these three along with one case law at least each, right? And the crux of the answer will be that if it is mandatory by the scheme of the whole act, if it seems mandatory, right, then if you do not follow the safeguard, right, then the procedure and then the delegated legislation shall be held invalid. That is the main point. Understood that particular point? Okay, right? So while conferring on delegated legislation on administration, the enabling act may specify procedural safeguard to be followed in the exercise of the power, full stop. What are the consequences of non-compliance with such requirement? Okay, so the consequence of non-compliant is basically if it is mandatory, which can be understood by the scheme of the act, right, then non-compliance will lead to declaration of that particular delegated legislation as void. Okay, non-existent. Now let us come to question number 3b. Now if you look at 3b, this is again a philosophical type of question. I have already told you that most of the question, the number of questions especially in the constitutional law in 2019 have increased to 30%, 40% is philosophical. Okay, it do not require a very specific study. Well, you have to make answer in such a way that it seems to be legal, but it do not require to be. It can be a paper 2 question as well actually, right? Let us see question number 3b. 3b says, the Election Commission of India is an autonomous constitutional authority responsible for administering the election process of India. Okay, autonomous body responsible for election process in India. Full stop. In light of this statement, discuss power and function of Election Commission. Function of Election Commission. Right? Power and function is there, right? Power and function, yes. Now, what actually you have to do here? One way is that you can write, okay, these are the power, these are the functions, right? But that is actually not how you will write it. I have already told you this is type 3 question in the type of question that I always tell, right? This type question is there. This is a statement, and in light of this statement, discuss this, right? So basically, your question is this. Your question is this, and conclusion is this. It means you have to discuss power and function in such a way that you reach to a conclusion. The Election Commission is an autonomous body, okay, responsible for administrative election process in India, right? So it means you have to talk about it is very autonomous body and it very effectively administers the election process of India. Okay, right? So the answers should not be directly simply writing power and functions. Okay, now how to go about it? Now remember, the structure should be, the whole structuring of answers should be, right, presentation of answers should be such that you have to specify power and function which somehow is connected with the autonomy and election process. Understood, right? How will you start with it? Now if you think about it, firstly we will talk about how the election machinery in India is basically 2 layered. Okay, there is an independent mechanism for certain elections with the State Election Commission, and there is an independent mechanism for Election Commission of India which conducts 2-3 elections, right? Then you will little bit talk in the introduction part itself that how the power and function of Election Commission is not exactly defined in a very detailed manner. It is a sort of a summary power, right? In CPC we have summary power, right? Overall power, right? Like, and then you will come to the body part, and then you will talk about that how that power is basically for the purpose of administration, right? Then you will write, when critical component in the article 311, not 311, sorry, 310, right? That actually talks about, no, not again 310, what is the Election Commission? Acha, sorry. Now in that particular article, specifically 324, specifically talks about that, see, the President and the Governor shall make available all the staff necessary, right? The President and Governor shall make available Election Commission or Regional Election Commissioner all the staff necessary for the conduct of duties conferred upon them. Now all the staff necessary, which staff? right? Now the word staff have been interpreted so widely that any staff, okay, so it means that it is practically a sea of power. An election commission can take out as much power as it want. Okay, you want executive, give me that executive. You want legislative power, some not exactly legislative power, army, you take recusal army. Okay, you want control over the transfer and promotion, you take it. Okay, it means all staff necessary. This whole word gives a very generic or sort of a summary power to election commission. Okay, now again I am telling you, this word has to be written along with the power mentioned above articles, right? What are the power mentioned? The power mentioned is basically conduction of election, then you have preparation of electoral roll, right? Then you have concept of supervising of election, right? Supervising of election will consist of everything, right? Campaigning to here, everything. Okay, then you will, second power that you will write is very important, is the dispute resolution power that election commission have. Okay, now what is the dispute resolution power? It says that, okay, if there is any dispute, more or less, you will complain to an authority which is appointed by election commission to solve that dispute. Now if you are not satisfied with that particular authority judgment, then only you will go to the high courts, right? Then only you will go to the high court, right? So there is a sort of a problem solving mechanism also over the administration process. Okay, so that point again has to be bettered up. That point also has to be emphasized, right? And then you will write in the end that high courts have been more or less have adhered to the principle and have not ordered election commission election dispute to judge at the first instance instead of second instance. It means ki generally if you go to the high court with election petition, they ask you to first go to the election commission. Again, if you come to the high court directly against a particular election mechanism or any particular problem that you might have, right, then the high court generally ask you to go to the election commission and ask for a judgment, ask for a decision, right, and then only the high court hears you, right? So more or less high court have not interfered with the election process, right? Very rarely high court have stayed a particular election, right? It almost never has happened. Okay, I think one or two instances are there, but almost it has never happened. Okay, so that point actually you have to focus, right? That point actually you have to focus. Understood that particular point? Okay, right? So you have to talk about power and function in such a way that the first statement is basically buttered up. It is basically the conclusion. Understood that particular point? Okay, now this is only a guideline because philosophical question can take multiple shapes actually, right? When you have a very simple straightforward question like the previous question with regard to delegated legislation, so the structure will remain same, right? Because very pointed question, concept based, right? But it is a very philosophical type question, right? So it should not be like that right power and function, etc., right? That will make your answer very bad actually, right? Because the exact requirement of the question is that you have to use power and function to support the argument that the election commission is an autonomous body and it administers the election. That is the two argument you have to support. Understood, right? Now again, this is only a guideline because philosophical question can take multiple shape. Okay, it can take really multiple shape. Now let us come to the last question of today's discussion. Now one more thing actually I wanted to say to you is that I have asked de facto people, they are uploading it obviously on YouTube, right? But one thing, there is a 30 question in paper 1 actually, right? Again we have 30 question in paper 2. Okay, so just having 30 question, it will take almost 2 months for one particular if I take 5 to 6 class around 2 question each, right? So at least it will take 4 days, right? So it will take 4 week, right? So 4 week, only 1 month, right? So if we discuss paper 1 and paper 2 of 2019 only, it will take 2 months actually, right? So what I will try to do that I will try to give you 2 videos per week, right? So that at least de facto people will process and upload it on YouTube, right? So that will be helpful for you. So that my aim is the next 5-6 months at least complete 5 years question, right? If you only complete 1 year question in 2 months, it will take a huge time actually, right? Up till then new means will come actually, right? I will try to do that, but I am not promising you one video confirm I am promising you, right? But still I will try to do it. Okay, so keep that particular thing in mind. Now question number 3C, again a typical question, right? Philosophical again. It says India, that is Bharat, shall be a union of state. Article 1 clause 1, India, that is Bharat of our constitution, union of state, right? India, that is Bharat, India, that is Bharat, shall be union of states. Okay, and Constituent Assembly, the word Bharat was debated. Someone said it should be India, that is Aryavart. Someone said it should be India, that is Hindustan. Finally they settled on India, that is Bharat. Full stop. Explain. Do you think that the Indian Constitution is a federal constitution? Discuss with the help of decided cases. Now this is a typical question where always they ask you to comment on the nature of Indian federalism. Very typical question. The format might be different, right? They might say you India is a quasi-federal, quasi-unitary constitution, comment. India is, is a federal constitution with subsidiary unitary provision, comment, or other way around, right? So the answer requirement actually is same, that you have to comment on the whether India is federal, quasi-federal, quasi-unitary. That is only the requirement of the question, right? Now that is the second requirement. First requirement in India, that is Bharat shall be union of a state, right? So in the first part of the answer, basically you have to answer this, you have to explain this. Then in the second part of the answer, you have to talk about the nature of Indian federalism. Okay, so there will be a two-part answer. I think it is a 20-mark question. Yes, it is a 20-marker question. Okay, so 10 marks, 10 marks, right? So 150 words, 150 words. Now, if you look at India, that is Bharat, then typically always understand the concept that when we talk about the word union, right? So union means basically one entity have devolved into multiple entity. It is not a result of coming together. It is a result of devolution of power, right? When they come together, that is basically referred as federal. Okay, that is referred as federal, right? For that there is a very famous explanation. This same explanation is given by Dr. Bhimrao Ambedkar. You quote that line verbatim, a whole paragraph actually, 5-6 line, quote that verbatim and explain with the help of diagram. Here actually you can make diagram, but do not take half page of making diagram, just a simple point. Understood? Then you write, this have affected Indian federalism, right? So the very concept of the first part, that is the explanation of union, has affected the nature of Indian federalism. How? Think about a very common sense point here, that suppose there are 5 states, 3 states that came together making a particular country, and there is one state, larger state, that have devolved into a smaller number of provinces, states, right, and that have formed a country. Now who do you think at the time of writing the constitution will have more say in the constitution? Here the union have been formed first, then the states. So obviously the union will give power what they want to the states. But if 2 or more states comes together, then what will happen? It is the state who will determine what powers will be given to union. Understood? Right. So if you look at this type of constitution like in other states, you will see that most of the power lies with the state, very few power goes to with the union, because it is the state who decided what powers should be given to the union. But our country is like this, right? So that line will link your answer from this to the last answer. That is the nature of Indian federalism. Now, when we talk about then we will talk about nature of Indian federalism, right? Now, if you a very typical thing, if you think about the nature of Indian federalism, basically the conclusion remains the same, that it is neither federal nor unitary, right? Now, case law, the best case law, Justice Ayers, that talks about Indian constitution is amphibian in nature. Right, a state of Rajasthan versus a state of West Bengal versus Union of India, a state of Rajasthan versus state of Punjab, Union of India. Okay, similarly we have a state of Haryana versus state of Punjab, and 2-3 very typical cases, right? So you write those cases down, right? Then you come up with at least 3 argument, or 3 argument is also okay, but in the 10 marker 2 argument will also suffice. 2 argument given by H.M. Siravai with regard to the constitution structure, right? Okay, he very beautifully have portrayed that how there are some article, when you will read it, it will seem like a federal article giving power, unitary article giving power to the union, but actually it has, those articles have given a strength to states. Okay, like article clause 2 and article 2 and article 3, right? Specifically article 3, it says that the union parliament may divide any states, right? But mostly it is the state which have forced the union parliament to divide themselves, right? So those article might seems to be unitary, but in essence it is a federal article, right? Why? Because it have empowered the states, it have given power to states. Okay, right? So these 2-3 argument with regard to justice, H.M. Siravai, you can actually write that down, right? And then you conclude with the same provision that it is quasi-federal, quasi-unitary. Okay, you can cite Dennings also, if you want. You can cite Austin also, right? Or this professor, what is his name, very famous professor, you can cite him also. Jennings, Professor Jennings, you can cite also, right? Multiple professors are there, right? But at least if you cite 3-4, that's all right. Okay, if you want, you can cite our what is the name of the author, Corner State, Granville Austin also. You can cite Granville Austin also. Okay, so cite 2 to 3 authors and then conclude that okay, it is quasi-federal, quasi-unitary. Okay, there you need not to go into detail, about each and every provision, right? Because if it is a one question that okay, comment on the nature of Indian federalism, then you have to write unitary features are this, federal features are this, right? Very detailed, citing the constitutional provisions, right? So that is actually here not required, right? Because it is a 2-part question. Understood that particular point? Okay. So that will end our today's discussion, right? The next class, what I will do, that I will talk about question number 4 and question number 5, right? Question number 4 contains 3 questions and question number 5 contains 5 questions. Okay, question number 5 of part B of paper 1, right? So that contains 5 questions, right? And that will be question related to international law. Okay, so that I will cover tomorrow. I mean, in the next class whenever we have. Okay, so same thing. I am recording this on Saturday. It will get processed up and by Monday it will be uploaded. Understood that? Okay. Now, some of you have been asking questions, I think, in comment section, right? So generally do not reply to comments, right? But I will try to reply down if there is any standard question. If the de facto people will tell me there is some specific question, then I will reply to that as well. Okay. So that I will do. Okay. So that will be all for today. Thank you.